Good morning, Professor Proelss. It's a great pleasure to have you with us and to have entertained this conversation about your extraordinary work, particularly focused on the law of the sea. But for our listeners, let me first introduce Professor Alexander Proelss. He is the chair of International Law of the Sea and International Environment Law, Public International Law, and Public Law, and he's currently based at the University of Hamburg in Germany. Professor Proelss's research focuses, among aspects of general international and European law, on the international law of the sea, international environment law, as well as the international aspects of German constitutional law. He's involved in several legal and interdisciplinary research projects and has advised public agencies, international organizations, private companies, and NGOs, non-governmental organizations. So we are very honored to have you here, Professor Proelss, and let me start immediately with a first burning question, and that is, what spelled the fascination for the ocean for somebody like you who has studied law far from the coast in Bonn and Tübingen, to the point that you focused your doctoral thesis on ocean protection?
Well, first of all, good morning, Ms. Nauen. It's a pleasure to talk to you. And then to come to your question, as always in such situations, chance does indeed play a certain role there. When I started studying, or rather when I moved to the University of Tübingen, I just saw this piece of paper on one of the blackboards announcing a seminar on the international law of the sea. And I have to confess freely that until that point of time, which means after my first 2.5 years of studying law, I've never heard of the law of the sea. I didn't even know that existed. So I was attracted by it immediately and registered, and this is how it all started. But I suppose that family tradition does also play a role here. I'm a northern German by origin, and my family has for generations had a very strong affiliation to the oceans. So I assume that this is just the way how I do follow this kind of tradition.
Yeah, so we're less surprised. Following on from your family in interest or association with the sea somehow, what do you consider the 3 greatest threats to the ocean?
That's a good one, simply because there are many fundamental threats. Now, allow me to name 4, if you do not mind. I would first start with referring to climate change, which may be somewhat surprising for people from the maritime scene, but at the same time, as we all know, climate change has significant consequences on the ocean, thinking about sea level rise, and of course, when it comes to the marine environment, ocean acidification. Now, I think that this is one of the challenges it's perhaps the most serious one. Secondly, the overexploitation of marine resources, and in particular marine living resources, and of course I'm thinking about the global fish stocks here. Thirdly, I think that land-based pollution is a matter of utmost importance. Just thinking about the introduction of plastics and microplastics into the marine environment, also a particular challenge with regard to regulation. And if I may, number 4, of course, also thinking about the conservation of marine biodiversity, in particular in areas beyond national jurisdiction, which means the high seas, taking into account that these areas are outside of the jurisdiction of any specific state, which makes it a particular regulatory challenge to address this conservation task.
Yeah, and it's of particular interest, of course, in the light of the 2 conventions of the parties in Glasgow beginning this weekend, and then in Kunming, the decisive part in March next year for biodiversity. But one step back, in 2017, you managed to publish an exhaustive commentary of more than 2,600 pages on the law of the sea that was negotiated, and that body of legislation was negotiated over 10 years and eventually entered into force in 1994. By now, 167 countries, I believe, have ratified the treaty, deposited accession instruments with the United Nations, or adhere to it. In every sense, the treaty itself and the efforts to understand and interpret its use under rapidly evolving conditions are massive. How can it address these threats effectively?
Well, this convention on the law of the sea, which was negotiated between 1973 and 1982, and which then took another 12 years until it could enter into force, is a very special international law document. It's not only the most comprehensive treaty that was ever concluded between states, but it's also something which I believe is correctly called the Constitution for the Oceans. And this character as a constitution is telling us a couple of things. It is really a framework convention which must be and which can be adapted to new challenges. And this is done by numerous references included in this United Nations Convention on the Law of the Sea on other documents, which means that if you want to adapt this treaty to new developments, it is not necessarily mandatory to change it or to amend it, which would be perhaps impossible to do, but rather you can influence its content and the content of the obligations which are codified in this convention by changing the international treaties and other documents, soft law documents, to which it refers, which is a very, very smart way of keeping an instrument up to date. Let me make another point. The convention has also been described as a living instrument. The majority view really is that it cannot just be interpreted and applied in the way how its terms were meant in 1982 when it was adopted, but rather that it has to be interpreted in light of new challenges and developments. And that is, I think, one of the massive assets of this treaty, that it is actually possible to apply it, to keep it up to date, and then also to include issues such as climate change, for example, into its scope. So I believe that this really is one of the fundamental things with this convention. And if I may just make one word on the treaties, which you mentioned at the beginning, the book publication, the commentary. Of course, I did depend on the work of altogether around 60 co-authors. So, you know, as an editor, you cannot be hailed for the entire content, but it's more or less the task then to collect the material and to participate in it, review certain contributions. But it's true, it was a lot of work, and it did, last for several years.
And that's very interesting to hear. And if I just pick up one element of the convention and how things are evolving, I'm thinking immediately on the run for deep sea exploration and mining concessions granted by the somewhat little bit obscure International Seabed Authority that was created under the law of the sea, spawning new controversies. It moves us further away from the notion of the common heritage of humankind to be preserved for future generations, it seems. And that plays a role during, or played a role during negotiations, and in order to level the differences between industrial and developing countries. And clearly they carry different weight in terms of their capacities in various spheres. and where naturally it's very difficult to let's say, achieve something that is fair to everybody. How do you assess these developments?
Well, as a starting point, let me emphasize that the International Seabed Authority is an international organization which is foreseen by the United Nations Convention for the Law of the Sea, and it has actually been tasked with duties that refer to assuring and safeguarding the common heritage of mankind, and to come to a fair and just distribution of the benefits, including in particular those states who do not have the technology to entertain deep seabed mining. So from that perspective, I would, if I may, be far less critical. It is just the institution which was established for that very purpose. Now, one thing is true, though, following the adoption and conclusion of the United Nations Convention on the Law of the Sea, there was a 12-year controversy between different groups of states, and the industrialized states then managed to use their influence in order to, ultimately come up with an implementation agreement to the convention, which changed parts of the content of the pertinent provisions concerning the deep seabed and the common heritage of humankind, to the disadvantage of the poorer states. At the same time, at the time, this was the only way of getting the United Nations Convention on the Law of the Sea into force. So I think that this was kind of a compromise that was without any alternative. As far as today's development is concerned, the International Seabed Authority has, I believe, done a very good job in negotiating and partly adopting the regulations that need to be adopted in order to provide for legal certainty, but at the same time to provide for the needs and the protection of the marine environment vis-a-vis deep seabed mining. Now, this process of adopting and developing these regulations is nearly finalized right now, which would theoretically then make it possible to start deep seabed mining in the nearer future. Of course, it's a political question if we want that to happen or not. And I wonder sometimes whether it really makes sense to, to start exploiting these kinds of resources if we at the same time really need to shift to renewable energy and to alternative resources in order to prepare for global warming under the climate change regime. But that's a political question. As far as the legal perspective is concerned, I would generally argue that since the entry into force of the Convention on the Law of the Sea and the 1994 implementation agreement, everything has happened in the way that it was supposed to happen, first. And secondly, it is also fair to say that the International Seabed Authority did pay a lot of attention to the protection of the marine environment. So I think it would be unfair and unjustified to say that these issues were ignored. They were not.
Thank you. Let's say perhaps I follow you that they were not ignored, but as you were also pointing out, there is a balance of power and capacities, and that may sometimes shift the balance in one direction or another.
Exactly.
In these days, yeah, sorry, please go ahead.
Just one comment during this wonderful conversation. It is also true that the entire system has not yet passed its practicability test. So we really need to wait and see how this is going to develop. And it is of utmost importance that it will be effectively observed whether the Seabed Authority will then pursue its duties in the way that the convention has envisaged it to do. And that is certainly something which does indeed affect the what used to be called the developing states.
Yes, and it's a small authority and with a huge task. So its life is not easy, I think, to put it mildly. Somewhat related, not perhaps directly, but there is also a lot of geological research going on. And that is used to demonstrate that morphological structures on the seafloor extend beyond the 200 nautical miles of the standard exclusive economic zones that were granted to coastal zones and their islands. The claims are vetted by, also, again, a very small group of scientists. And some people speak even about ocean grabbing or sea grabbing in this context. How extensive is this development? And what do you see as a major consequences? Could that perhaps even serve to improve ocean protection in the sense that individual countries acquire responsibility for a greater maritime space? Of course, also with the question, will they have the means? Because it's all very well to declare it, but you also have to be able to do it. And we see that it's not easy in practice. But what would you say from your perspective?
Absolutely. Well, what you're referring to is a development which started already after the Second World War, and which, put in legal terms, is referring to entitlement for an extended continental shelf, which is, to put it simply, the seabed and subsoil underneath the exclusive economic zone. But as you correctly said, the law of the Sea Convention envisages that this entitlement of coastal states may, depending on certain geographical circumstances, even extend far beyond 200 nautical miles. And indeed, if a state is declaring such, or I'm using the word claiming here, which is not completely correct from a technical perspective, but I'm using it here for the purpose of demonstrating what I intend to say. If a coastal state then claims an extended continental shelf, then it has to provide the scientific information to the Commission on the limits of the continental shelf in order to demonstrate that that part of the continental shelf is, as it is stated in the convention, a part of the natural prolongation of the land territory. In other words, to put it simply, a kind of underwater part of the state territory. Now, once again, we may, like it or not, from the perspective of politics or conservation of the environment, it is foreseen under the law of the Sea Convention as a process. And it is quite an extensive process, taking into account that so far 88 states have submitted information to this commission. That's quite a lot. And about a little less than a third of these submissions have been dealt with by the commission, and the commission has made recommendations on the outer continental shelf, in some cases saying that the scientific information that was put forward did indeed back the claim presented by the coastal states. In other situations, however, coming to a different result. Now, can the continental shelf regime be used in order to perhaps even increase the level of environmental protection? I doubt this. The continental shelf regime is really one that refers to the natural resources, and I'm thinking of oil and gas here in particular. The sovereign rights of the coastal state on the continental shelf include one specific category of living resources, namely sedentary species. Now, these are particular species that arguably can then also be protected and conserved by the coastal state, but in its origins, the continental shelf regime is really one of exploitation. So I'm kind of skeptical whether that is the appropriate regime really to foster the level of environmental protection and nature conservation. The things may be different with regard to the EEZ, but at the same time, even though coastal states have indeed environmental jurisdiction in this zone, let's also not forget that the EEZ is, as far as its origins are concerned, a fisheries zone. And that is then again something which may well conflict with the needs of sustainability and the needs of effective nature conservation and environmental protection.
It's something that is a bread and butter topic, really, in terms of how we manage our resource or the resources more sustainably. So far, we have not really excelled at that, but we hope that through various negotiation processes and awareness raising work, perhaps we manage to find a more intelligent way of projecting this into the future so that we don't eat the capital of which we want to draw interest in the near future and in the far future. But somehow related to that, let me move on a little bit exactly to these natural resources. And I found a very interesting article you have published with fisheries biologist Dr. Rainer Fröse from Geomar, using also legal reasoning to argue that resource management and protection should really be actuated and acted upon. Who looks after this sort of implementation requirements of the provisions of the law of the sea?
Your question really points to one of the fundamental dilemmas of international law in general, and that is we don't have a world police. There is no centralized body that is tasked and responsible for observing effective implementation, in particular, of environmental protection and conservation provisions. Rather, this is the task of each individual state and of the different groups of states. And if I say groups of states, I'm referring to flag states here, to the coastal states, and to port states. In addition to that, some international organizations have been created, such as regional fisheries management organizations, which are on the one hand, first and foremost, responsible for adopting fisheries measures, such as total allowable catches and so on and so forth. But at the same time, they also have been allocated certain monitoring, implementation, and enforcement powers. Now, in addition to that, of course, international courts and tribunals play an important role in this respect. But at the same time, because of the doctrine of sovereignty, it is not always, I should rather say, possible for a state to challenge the conduct of another state as not being in line with, for example, the UN Convention on the Law of the Sea. And furthermore, it is not possible for individuals or individual non-governmental organizations to challenge the conduct of such states. That can only be done in front of national courts. Now, ultimately then, it is really a kind of a mixed system. Its responsibility for implementation and monitoring of implementation is split between states, international organizations, but also, and I think that's very important, the general public. And representatives of the general public are then non-governmental organizations involved in environmental matters, who will then observe on the basis of scientific facts whether or not a state is applying the law in the way it should be done, and if not, trying to criticize the state and to create public awareness. But the dilemma remains. There is no centralized implementation enforcement body available, and that is just part of the structure of international law. So it is extremely difficult to overcome this problem.
Yeah, we saw some of these challenges as well in, let's say, instruments that don't even have the legal status of the law of the sea. I think in particular of the Code of Conduct for Responsible Fisheries and the voluntary guidelines for ensuring sustainable small-scale fisheries in the context of food security and poverty eradication. These are among several international frameworks which express ambitions, but are chronically difficult to implement, as several pieces of independent research work have demonstrated. How do you see the continuum from voluntary guidance to hard law in securing a healthy ocean for future generations?
I would perhaps not find it necessarily a disadvantage if a certain document, such as the Code of Conduct for Responsible Fisheries, is not legally binding per se. There are indeed a certain number of publications available that demonstrate that sometimes, it really depends on the circumstances, right? But sometimes soft law documents can just be as effective, maybe sometimes even more effective than hard law documents. Now, this for a legal scholar is kind of a strange conclusion, and it's not what I would have expected. But it may have to do with the fact that sometimes for states, it's easier to simply follow what they know is not mandatory in terms of the law, which means that if they are not in the position to completely fulfill it, they cannot be held responsible. So, you know, there might be some kind of psychology of states in this sense. Secondly, I think there is also some good news, and this leads me back to one of my comments I made earlier. The Law of the Sea Convention does indeed include references to other documents, and that's important, also includes soft law documents. So in the provisions on fisheries in the Law of the Sea Convention, you will find references to documents which I would argue includes the Code of Conduct for Responsible Fisheries. So through the back door of these provisions, the code actually does become a de facto binding standard under the Law of the Sea Convention. So I think that the situation is not that serious with regard to this categories of soft law and hard law. And I think that focusing on the interlinkages between the two categories is an important task for legal scholars around the world to further observe and to continue to, to work on, because I do see chances here where states find themselves not in the position to negotiate binding law. So this could actually be a working alternative.
That's very interesting, and actually underscores also spaces where other organizations and citizens can sort of make their voice heard, perhaps, and contribute to the chorus, and together evolve towards something that is perhaps a bit more sustainable than what we experience right now. So there is hope. Now, where the situation might be a little bit, or at least as complicated, is I remember in the late 90s, the UN tried to develop a legal instrument that would bring serious environmental damage into the realm of penal law as a deterrent to reckless pollution. The argument at the time was that irreversible damage could not be remedied with insurance and compensation approaches. Moreover, human victims had rarely been compensated, as even the one significant resources of the EPA's Superfund in the USA were largely insufficient to clean up pollution abandoned by industrial actors. And these attempts came to nothing at the time because legal traditions and environmental awareness were too far apart for a global consensus. A little bit what you described a minute ago. What has happened since on the legal front to protect people and planet and exercise, let's say, have an attitude of precaution prevail rather than trying to remedy after the fact?
Hmm. A couple of remarks, if I may, first on remedies, ex post remedies, taking into account that with regard to a certain category of damage, and that refers to spills from persistent oil from oil tankers, which means ships, there is a liability regime of addressing operators in place, which, if I may use this word, culminates in the oil pollution compensation funds. So I think on that issue, something is available. Now, it's correct what you said. It's always a question of what kind of damages are covered first, right? In particular, what about environmental damage, irrespective of individual human damage? And secondly, are there sufficient means available? That's always the big thing. And it's interesting to see that on other fields, there are no such liability regimes in place, which means there's obviously a legal vacuum in this respect. Now, your question is highly topical from another perspective, because right now there are ongoing negotiations and discussions on whether or not a new crime, an environmental crime, should be included in the statute of the International Criminal Court. And this crime is often referred to with the term ecocide, in order to make to clarify that what is at stake are serious fundamental crimes vis-a-vis the environment. Now, this is a very controversial discussion. I personally would say there are advantages, but also challenges of this conception. And we will need to wait and see how this is going to, be received on the international level. But it's interesting that many states, and that also includes some European states, have started to enact legislation within their national legal systems on ecocide. The problem being, however, that the definitions of what actually is covered by that concept differ. So it's not easy to, to make general conclusions on that. Maybe that much as to the ex post liability and responsibility approaches. But your question is far broader than this. And it is true that what we really need is precautionary management of the environment. I think it is today not possible to say anymore that we shouldn't touch the oceans anymore. That is kind of unrealistic. But what we do as human beings need to be done to the greatest extent possible in line with the needs and requirements of environmental protection and nature conservation. Now, I think that the ongoing Intergovernmental Conference on BBNJ, as it is called in UN jargon, which means biodiversity, conservation of and sustainable use of biodiversity in areas beyond national jurisdiction, will perhaps just be one of the fundamental cornerstones of the future regime, but we will have to wait and see whether states are ultimately going to agree on an agreement, which is, I would say, not completely clear. But I'm still hopeful in this respect. And indeed, this idea of caring also for the environment and those areas beyond jurisdiction is important, because obviously the environment doesn't care about the artificial borders that human beings and states have drawn on the planet. As we know, the facts are just very, very different. Everything is interconnected. And for that reason, it is important to focus on this idea of coherence between the regimes that apply in different maritime areas. And I think that is one of the main challenges for the future.
Thank you. And in a way, to continue a little bit this thought, after World War II, nuclear waste, ammunition, and toxic waste were dumped into the ocean as a matter of course. Meanwhile, we've learned, of course, that the ocean is the biggest ecosystem on the planet, connected through global ocean circulation. Yet we release plastic waste, mostly through rivers, abandoned fishing nets and some shipborne sources. And we provoke various types of pollution through massively increased global maritime traffic, other activities, and not the least through excess nutrients from industrial agriculture, etc., etc. In fact, you identified this sort of pollution as the third most important threat you assess as such. Which institutions and legal frameworks are best suited to step up protection and avoid irreversible damage? And what do you think are the most promising approaches to increase the effectiveness of the rules we already have? Because many of your comments alluded to the fact that we have a certain gap even between what we can agree in negotiations, but then implementing and enforcing it in practice remains a big challenge. So what is your experience and view in this arena?
Well, I believe that it depends on the source of pollution or the environmental challenge that is to be addressed. Think about pollution from ships. Then we do have the International Maritime Organization with the competence to also address this kind of pollution. And I think that, you know, we all wish, I do wish, that more would have been achieved, but I think the general assessment is that the IMO has been comparatively successful in negotiating agreements with regard to shipborne pollution. And it has also addressed certain tricky and controversial issues, thus contributed to the general regime. Now, at the same time, we, as I said before, we would wish that more steps could be done. And here I see a big opportunity and, you know, an important role to play for what is called supranational organizations such as the European Union. The European Union is very special in light of the fact that it has a mandatory or compulsory system of enforcing the legal obligations under its regime. So if the EU becomes a party to international instruments, it then is given the opportunity to enforce these instruments vis-a-vis its member states, which means the member states of the European Union. Now, once again, of course, this presupposes the political will on the side of the European Union to do such effective implementation, but there are examples demonstrating that it has tasked this duty and it has accepted this kind of responsibility, not on all areas, but I would say on some areas. So that is, I think, a model that could be discussed also for other areas in the world. At the same time, of course, taking into account that this requires political will to enter into such commitments. Now, the particular problem with regard to land-based pollution is that there is not even any kind of competent international organization in place. And there is a reason for that. Land-based pollution is obviously, you know, refers to something which enters the marine environment via land-based sources. And from that perspective, it is covered by the state law, right? The individual law of coastal states. So I think what we need to focus on is combining, for example, the law on freshwater protection with the law on marine environmental protection, because it is, again, interrelated. And I think this is one of the examples where the EU really has played an important role with the Water Framework Directive, which is, although it is a freshwater instrument, at least for its most part, has contributed also strongly to the protection of the marine environment. Now, the objectives of this directive have not yet been achieved, but it's true that it's frustrating that things take so long, but this is, from a regulatory perspective, certainly something which should be taken into account also with regard to other areas of the world. Interlink better those systems concerning domestic including freshwater environmental protection with the regime for the protection of the marine environment. If I may make one final remark on this, the matter of which institution should be competent to deal with a certain environmental regime is just discussed right now in the context of the BBNJ negotiations. Some states prefer the idea of a global institution that is going to be tasked with monitoring the implementation of the provisions of the future agreements. Others say we need regional institutions, simply because regional institutions take a closer look at the specificities of a certain maritime area, say in Western Africa, in Southern America, or in Europe. A third group, and I think that's an interesting suggestion, a third group of commentators has came up with what they call a hybrid approach, which means a global governance framework that is then going to task regional organizations with making implementation of the future agreement more effective. And if I may add that, all this is not sufficient. We also need effective enforcement and implementation on the level of individual states, but even on the level of the local communities. So all this needs to be interlinked with each other, and I think that has not happened yet. So this is what we should focus on in the future. And in particular, the local level is important and interesting because it has virtually received zero attention within international legal scholarship so far, taking into account that the local communities have so far not been considered as relevant actors under the law of the sea. And I think that should be changed.
That's a very interesting thought. And well, I think that merits an interview in its own right. But let me perhaps just to conclude with a big topic, perhaps come back to what hangs over all of us, and that is climate change, which actually is not something in the far future. We already experience some of the early effects. And we certainly see that already in how ocean ecosystems change, fish move polewards, etc. What do you see as the most promising avenues towards more cooperation, including on legal matters, to meet the targets of the 2015 Paris Agreement? And that takes you perhaps from the previous conversation. It's very clear we need more cooperation, don't we? How to get there? Of course.
Oh gosh, this is such a difficult question. Now, the first thing I would like to say is the climate change regime under the law has developed almost independently of the oceans, right? And I think, you know, that should be changed. The ocean is the biggest sink for greenhouse gases that we have on this planet. And from that reason, it is so strongly affected by everything which has to do with climate change and global warming. So we should not forget the ocean in this perspective. Secondly, I really think that, you know, the main tool really is reduce greenhouse gas emissions, reduce it even more. We need to become climate neutral as fast as possible. And climate neutrality is also not the end objective, but rather just a step until, you know, in order to even reduce it to the extent possible in future. Now, we know how difficult this is. This will not work without cooperation. We need more than just, you know, nominating nationally determined contributions every 5 years or so. We need very challenging target goals. And I believe one thing, and that is particularly important for the oceans, and I know that this is a controversial matter and that is not liked by many environmentalists, we need to think about ways of how to increase the CO uptake of the oceans. That has been accepted by the IPCC. It has been accepted by the UNEP that it is probably not possible to achieve the goals of the Paris Agreement without deploying, to some extent, carbon dioxide removal techniques. Now, as I said before, I'm fully aware of what kind of controversial issue this is. So I would strongly insist on focus only on those activities that do not harm marine biodiversity and that do not harm the protection, the oceans in their oceanic ecosystems, excuse me. Such activities are available, I think. They may potentially even counteract oceanic acidification. That would be wonderful if this is possible. And we should never use these kinds of technologies in order to, stop reducing CO2 and other greenhouse gas emissions. That's the number one task that we have, and we need to do it as much as possible. Now, cooperation, that was your original question. States do cooperate, but global cooperation is sometimes really just the quest for the smallest common denominator. This is something which is so depressing. And how is it possible to change this general attitude? Well, I think you need certain groups of states which accept the role of pioneers. I think that is certainly one of the roles to be played by the European Union, member states, and the EU itself. And then try to convince and to demonstrate to the rest of the world that investing in climate-friendly technology and to move away from fossil energy sources to renewable energy is something which ultimately really benefits sustainable development. In other words, which does not necessarily go against economic requirements and development issues, because let's face it. Human societies do depend on social and economic development, and societies will not accept anything which is contrary to these goals. So it needs to be, in one way or the other, harmonized. And I think that is one of the tasks of those who have the political will to go this path. I know it's a disappointing answer to your question. I'm fully aware of it, but I simply I cannot deliver the world formula how to increase cooperation on this grand challenge. Just one final remark. What should be looked after is to make sure that all the approaches taken with regard to the fight against global warming need to be coherent. It doesn't make sense to implement certain systems if they contradict other climate change regulatory approaches. And I do believe that this is not done yet in sufficient manner. And with that, I just have to make a full stop here.
Thank you so much. So much food for thought. Don't think these are questions I think we all grapple with, but it was very interesting and very enlightening to hear your insights and get a flavor for the intricacies, but also the avenues that may allow for some steps forward. We all know it's not one size fits all thing, and it's just that we have to keep going. So thank you so much for this. And I hope we'll be able to act a little bit, at least, on the pathways you have suggested as the most promising.
It depends on people such as you, Cornelia, and the willingness of individuals to get involved. It is so important that this is happening. So let me also thank you so much for this wonderful conversation. I enjoyed it very, very much, and it was really a privilege to talk to you. Thanks.
Thank you.